What's going on? This is Colin. How's everybody doing? Happy Saturday nights. Hope everybody's well. I see a lot of people already rolling in. Jonathan, Phil, Heather. I saw Sashina. Got Kelly, Chris, Doggy, or Deb. Who am I missing? I know I'm missing some people. Scrolling through quickly. Got both Jonathans here. Legal Fiction, Jedi, welcome. I saw Peeps earlier. All right, let's get to it. So I've got longer video for you guys tonight. It's a little over an hour. If you guys haven't seen my premiere earlier this morning, go check it out. It was good. It's a little bit different than court. It was a town hall meeting instead. It was nice. But yeah, I've got an important thing to say. And I wanted to say this last night. Kind of got out at the end, but I'm in need of help. I'm in need of help again, and this is really hard for me to ask. Is I'm going to stutter a lot during it. As all of you know, I lost my job and got demonetized in about the same week. And now that I'm being remonetized and getting a job offer next week, but I'm a little short on rent. So humbly asking for anyone that could possibly donate to donate. And I know I'm e-begging, and I know I'm going to get trolls in the comments. So there's a big likelihood I'm not even going to read the comments to this video. But because of Phil, Craig, Fred, and Cauliflower, who donated since yesterday, the gap is a lot smaller, and it's very manageable, I think. I think we can do it. I hope so. But if anybody wants to donate, I would very much appreciate it. I would thank you very much for it. But yeah, man, that was hard. I don't like doing that. All right, let's watch some court. You guys want to watch some court? What do I have? I have, you know what? Let's just get into it. We'll watch it together. We'll figure out what I have. I know I have some McConico. Who else do I have? Who starts? McConico doesn't start. Don't even remember. And I just made this video about an hour ago. All right. Before I get into it, you already know what to do. Like and subscribe. Do your jump kick backflips. And if you would like to donate, I'd very much appreciate it, especially this weekend. Let's go.
On Hart, case number 22S00490.
Richard McDuffie for the people.
Here we go. We start with Judge Washington. Oh yeah, this is the police officer. No, it's not a. It's a correction officer. It's not a police officer. It's a correction.
More Mr. Hart, who's standing to the left. Please state your name.
Olajuwon Hart.
Good afternoon, everybody. You can have a seat. So I am arraigning Mr. Hart on a couple of things in addition to, I believe he's here for the contempt proceeding. Or is it just the VOP? Guess it's just the VOP, although it looks like it should be a contempt proceeding. So, sir, the new violation is that you failed a drug test as ordered and you failed to report to probation for over 60 days. The recommendation at this time is for 15 days in the Washtenaw County Jail and to continue you on your probation and follow your sober link guidelines. In addition to that, it appears that you have, one, called this court petty, two, basically told off everybody in the criminal traffic division, yelled at the probation coordinator. So there's a host of issues that we have going on here with you. Mr. Lebo, what would you like to do at this time?
All right, you want to just clarify the procedural posture here, which is my understanding was that Mr. Hart previously pled guilty to these VOPs and that we're here for a sentencing.
Okay, let me see if that's correct.
Thank you.
Well, one of them I just signed that's dated today, January 4th. So let me see. November 30th. Yeah. Ms. McDuffie, do you show that he pled on November 30th?
I do. I have that he, let's see, I have that he, needs to come in person for sentencing as of, yes, and then it was originally on the 12th, and then it was moved to the 14th, and then we changed it to today after the holiday. So yeah, I do have that he was getting sentenced on all of the other ones prior to today.
All right. Back on October 3rd is when I extended his sentence so he could get the requirements done. He was placed on probation with 18 months. Complete the Don Farm assessment, attend the Matt Victor impact panel. So, sir, you're driving while drunk, and I'm being petty.
All right, so yeah, this former corrections officer, I think he DUI is the charge. Ended up losing his job. You'll hear all about his story here in a second. But this is Judge Washington's courtroom. This is what it looks like when she has her in-person hearings. And because this guy has been yelling at everybody that he's come in contact with, even the judge, called the judge petty, he had to show up in person. He's in trouble.
Is there anything you'd like to say on behalf of your client before we proceed to sentencing?
Your Honor, I do have sentencing elocution.
Go ahead.
Thank you. So I did discuss this pretty extensively with Mr. Hart. He does admit that he let his anger get the better of him and that he should not have done that. He certainly doesn't feel that the court is petty, and he certainly realized that he should not have spoken that way to the traffic criminal department. But he's told me that he's working 2 full-time jobs, one at KFC from 4 p.m. to 10 p.m. and one at Comerica Park from 11 p.m. to 7 a.m. and one of those 5 days a week and one of them 4 days a week. He's also spending a lot of time with his son, who's just started middle school. He's trying to do it whenever he can, but he's not working. He missed the SoberLink because of those complications in his life. And when he called the court, he became very emotional. He felt overwhelmed. He told me that he feels like he's losing everything in his life because of this case. And that's been a very significant emotional impact on him. He was a correctional officer prior to this. He lost his job due to this case. So he's been going through a great deal of personal complications as a result of others in his life and a result of his actions that led to his conviction in this matter, and that led up to him losing his temper and letting his anger get the better of him when he spoke to this court's traffic criminal department and emailed with Ms. Straub. So that would ask the court to consider a sentence in lieu of incarceration, perhaps something that would help Mr. Hart learn to manage his anger more effectively.
Mr. Hart, what would you like to say, sir?
I would like to apologize to the court, Your Honor. Like he said, it's just been a very difficult time for me. So, you know, I do take the case serious. I don't want it to seem like I don't take the nature of all this serious. I do take it serious. I am trying to get my life on track. That day in particular, it just seems like every time I try to go to, you know, take steps in a positive direction, it's almost like I'm taking 20 steps backwards. You know, I haven't had anything to alcohol. I haven't had anything to drink. I've been compliant. So it just seems, I just get frustrated when I don't see, it just doesn't seem like it's a light at the end of the tunnel. So I know I can't behave that way. Obviously, I went out here and broke the law. So, you know, I have to answer to that. But, you know, I just want to say, you know, I do apologize. You know, that's not who I am as a person. I wasn't raised that way to be disrespectful. But like I said, I'm just trying to dig myself out of the hole. But it just seems like it's not a light at the end of the tunnel. So it's overwhelming and it's just frustrating. So sorry. Doing the best I can to comply with all the orders, you know, given the circumstances. And so, you know, all I can really say is going forward, you know, I can just, you know, get a grip on my anger and just, you know, just try to do better. That's all I'm really trying to do is just trying to do better.
He might be. He sounds humble right there. He doesn't sound angry. I think Mr. Lebo probably put a foot where he needed to put a foot to get him to start complying. But just look at the paused look on Judge Washington's face right now. She is not impressed by this guy. But I've already got 3 donations. Thank you so much to Legal Fiction. That was very generous. Thank you. Thank you, Gene. And thank you. I forgot I just looked. I didn't want to look. And thank you, Donna. Thank you so much. All 3 of you. I very much appreciate it. Very grateful. Thank you.
Mr. Hart, I can imagine that this is very different for you, this whole situation that you've gotten yourself into. You've taken a fall from grace to this. And it must be challenging to be humbled in this way. As a community, as a corrections officer, you were in charge.
DUI.
You had to tell people what to do. Now you're sitting on the other end. So the first question is, how'd you end up making the choice to be drinking and driving anyway? Which I'm sure you grappled with already on your own. So I don't know how you got there. I'm sure you do. How you ended up making that choice to bring yourself within the jurisdiction of a court, where you were in a position of enforcing the court's orders, enforcing the jail's orders. Where did you work?
Right here around Valley.
The women's facility?
Yeah.
Thank you, Donna. That was sweet.
You plan, so you got community service instead of having to do jail time, right?
Yes, ma'am.
I don't think you've come to terms with where you are. And I know it's hard.
Especially since he sees people that are there for DUIs all the time. I would just think you would think more than twice about getting behind the wheel when you've been drinking.
But I didn't make that choice for you. My probation department didn't. Neither did my clerks. The result of your actions, the repercussions with your job came from your job, not from us. And look at me, I'm sitting right here, over here. That came from your job, not from me, not from them. And you really aren't in control right now. And you can't talk to anybody the way you've been talking to them. And I understand that you're going through a lot and this is hard for you. So you got to figure out what you need to be able to get through this. As a corrections officer, you don't want to be spending your time behind bars. I don't want to have to put you there. But you're taking your anger out at the wrong people. Can you at least see that yet?
Yeah, I can see it. I understand it and I recognize it, And it's like you said, it's just pretty much trying to figure out, where I go from here. And it's like you said, I'm not in control, and it's like, I've never been in a position like that in life, So it's just, I don't know, it's just one thing after another. Life is life in general with all the stuff that we all have to deal with and go through and, just everyday life. But I don't know, just I had my life set for a way that it was supposed to go. And yeah, I messed it up. So it's just like trying to start over and figure out what now.
Your Honor.
Yes, you may proceed.
I mean, the question that I have, and I share the court's
Craig, good to see you, buddy. Absolute legend.
concern about Mr. Hart on a few different levels. As you mentioned, he pled his charge, but this is a second offense. So it's not just that he made a choice this one day to drink and drive. It was a couple years after his prior case. And I guess he had, I don't know if he had probation or what in that one. My concern is that, one, as a former corrections officer, we know that he should know better, but I think that he seems to be having some difficulty. I'm not trying to be a psychologist or anything, just grappling with the fact that he is also a quote unquote regular person, subject to the same consequences that he's been enforcing. And I don't think he sees himself in that way, which may be causing some sort of block for him to really engage in what he needs to move forward. But two, his record was clean before that first offense. I don't know what happened to cause him to make the choice the first time to go through what he had to go through on that case. And then with the break in time, do it again. Something else appears to be going on with him that is causing him to make those multiple choices. And I don't know, there's programming for alcoholism, if that is indeed what he's going through. There's programming for making better choices, but I don't know if he has been ordered or even availed himself voluntarily of any just general therapy or counseling for overall what's going on in his life. That's all.
Your Honor, can I have a moment to respond?
Could I just confer with Mr. Hart for a moment?
You may.
While they're conferring, if you haven't liked and subscribed already, please consider doing so. It does. It really does. And it's easy. Buttons are like right here. What's up, Ed? How are you doing, buddy? Yeah, Mo. Rachel McDuffie's awesome. She's really good.
Mr. Hart does have an additional statement you'd like to make to shed some light on what led up to his drinking offenses.
I just wanted to say this in response to Ms. McDuffie. Like she had stated, she said prior to the first DUI, my record is clean. And for the most part it is. I mean, the only thing that's on there is these DUIs. But I would say I didn't start obtaining, I was 26 when I got the first one, but I didn't, and that's around the first time, that's around when I started working, with the state and the correction is when I picked up. Prior to this, I had been driving. I've never had any incidences, but I will say this, Your Honor. Once I started working, in the prison system with co-workers and stuff like that, and the drinking I noticed increased. Just for the nature of the job. We all know what the nature of the job entails, but that's where this came. And it just, I don't know, the first one happened and then like you said a couple years ago, the second one happened. And kind of all work related. And so that's where that comes from. Other than that, I never had an issue with driving or drinking. I've never been in trouble with the law. You know what I'm saying? I never had a problem. I never was getting DUIs or anything like that. But I will say when I started working with the state, when I was working with the state, that's where these two DUIs came. That's where I picked them up.
This is when we need to stop talking about your case, please. Also, Jedi, thank you for the donation. And Craig, you continue to be a legend. Thank you so much. That was extremely generous.
With your coworkers drinking?
Yeah, just drinking and just leaving the bar and just got pulled over. So, I mean, but yeah, like I said before, I've never been in trouble before. This is the only trouble I've ever had with the law, with the drinking and driving. It just so happens that I happen to be working for the law at the time that I picked them up. So it's just like, that's where I'm at.
Well, some people who get positions of power think that it entitles them to be able to do things. But I see it as you have an obligation and a responsibility to be better. And, you know, if I were out drinking and driving and I got caught, I would no longer be a judge. I'd like be done. That's the end of that. I get that. And I would accept the consequences that come along with that because of whatever stupid choice I made. So I don't do it. In reality, you should have known that before you made these choices too. But you got caught up in what everybody else is doing. And that's how you wind up here. And now you're here again, not because of coworkers, but because of you, because you have chosen to see this process as nothing but a detriment to you, as opposed to the opportunity that it could potentially be. And it's hard, I get that, to see it, because you've lost so much in your mind. But as human beings, we are created with the ability to create opportunities and jobs and things like that. And you have skill sets that you just need to figure out where to place those skill sets into a new avenue. And get past your anger over where you are, because guess what? That part is done. It's done. Now all you can do is try to be a better person than you were then in a different way. And be a better human being, because who you're being right now is going to end you up in a place where there will be no upside. You're just going to keep going down. Because being in jail is not going to help you, in my opinion, to be a better person. Are you deserving of that punishment at this time? Yeah, you probably are. But I'm hoping that you can actually hear me and that you can figure this out.
I hear you, Joanna.
You got that job for a reason because of who you were presenting at that time. You need to dig deep back down and figure out who that person is. And become that person again, as opposed to the person that you've been. And you need to write a letter of apology to my staff and to my probation department.
Yes, ma'am.
I'm actually gonna not sentence you today because I want to know whether you get it or not. Because if you don't get it, then I'll send you to jail. If you do get it and you have a turnaround, I'll give you that opportunity. That's gonna be all up to you.
Yes, ma'am.
Stop blaming everybody else for your choices. My whole conversation about accepting responsibility and being a responsible human being is because you think that it's with your coworkers, and in a way you accept responsibility for it, but in a way I think you're angry that you were with them and you were doing this. This is your choice. These are your every one of them is your choice. Accept responsibility for your own choices. And I believe there's a program that involves that. Ms. Johnson, are you there? I know I've been asking a lot of you today. What is that program? That program that has people look at their own choices and accept responsibility for their choices. Do you remember which?
It is with Crossroads, and the name of the program, I'm pulling it up right now, Your Honor.
Your Honor, while Ms. Johnson is looking that up, can the people make an additional request that after he engages in whatever programming the court orders shortly, that he, and I'm specifically asking after that, if that happens, that he also write a letter of apology to himself?
And the program is the self-awareness program with the Crossroads Behavior Center.
All right, I'm not gonna sentence you today. I'm gonna have you do a couple of things. One, write the letter of apology to my staff, my clerks, my probation agent. Write the letter of apology to yourself. so you can forgive yourself and move on for what you've done and start a new path in your life, because you don't have a choice now. You've got to do that. And then I believe that program that she's talking about, is that a 1 day or what is that?
It is just a 1-day course, Your Honor. It is, should be a 4-hour class.
So you're not in control, right? You're not in control of what happens in this particular environment. You are in control of your own life now. This is where you can go negative, right here in this case that you have now put yourself in that space for. And I know what they say on the streets, and you've been in the jails and the prisons, so you know you don't want to be on paper, but you are. And just like everybody else, you got to do what the judge orders and what the probation department orders. Okay?
Yes, ma'am.
I will, okay, you can come down, you can go down to the probation department, they're gonna give you the referral, okay? I'll bring you back here for sentencing. On March 7th, 2024 at 11 o'clock a.m. I'm gonna make it in person again, because in case you don't do that stuff, we'll be looking at something different,
Yes, ma'am.
okay? So, get the referral for the self-awareness and write those letters, okay? I'm trying to give you plenty of time to do it, and you'll still be doing the rest of your probation at the same time, so. Do you have a new job?
Yeah.
You don't
I'm
have to
working
put
2
it
jobs
on.
right now.
I'm sorry, what now?
Yeah, I'm working 2 jobs right now.
You are, okay, he did just say that, you work 2 jobs. And that is making you angry because you were able to subsist with just your one before.
Yeah,
And
it's just too dedicated. You know, that's one thing. Is like, I just don't want to be doing it. You know, it's too.
They're not taking you anywhere.
No. So I got to go back to the drawing board.
But you can do that. Stop being angry about it and do it,
Yes, ma'am.
okay? All right. You're all set, sir. I'll see you on that day, okay?
Yes, ma'am. Thank you.
Well, that was fun. Yeah, it was. I think he's only charged as a DUI, but he lost his job over it, and he got really angry and started yelling at everybody. The judge, probation officer, even the staff in Judge Washington's court, and that's one thing you can't do. Judge will never put up with that. She might take it a little bit to herself, but if you start yelling at her staff and the probation officer, not going to work out too well for you. All right, I think we're headed to McConico now. And yeah, I saw that there's a troll here. And I'm going to ignore it. I will just say it's funny that that's the story that you were told. If you would like to know what really happened, you can message me and I'll enlighten you. All right. So yeah, we're headed to McConico now. Actually, we're going to WAP now. So I've got the first appearance in the arraignment in WAP, and then the follow-up in McConico. That's what we're watching now. Let's go.
0401, People State of Michigan versus Sioban Vincent. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Good afternoon, Your Honor. Kashava Kirkland on behalf of Ms. Vincent, who has been advised of her rights, which is to stand mute and waive the formal reading.
Also, Bonnie, thank you so much. Sorry, I got carried away because of the troll. So, Bonnie, thank you. I appreciate the donation.
Court read a not guilty plea on behalf of Ms. Vincent. Argument, Mrs. Coyle.
Your Honor, the people are requesting a $100,000 cash bond to have their house arrest. In this matter, there was a stolen car driven by the co-defendant. Defendant came out of the gas station and approached the car. There was a brief struggle to try to cuff the defendant. She was holding a handgun. She pointed the handgun at Officer Caldwell. Officer had to draw his weapon upon the defendant, told her he was going to shoot her if she didn't drop her weapon. After she had continued to make several threats to harm Officer Caldwell once released upon jail. I believe that she's a danger to Officer Caldwell as well as to the community. That is why I'm asking for the high cash bond, Your Honor, and monetization.
What was the amount, Mrs. Colin?
100,000 cash.
Ms. Kirkland?
Yes, Your Honor, may I have a brief second? Because I don't see anywhere where it says, she held a gun up at the officer, so I'm just rereading really quickly.
No, I remember that, from the report. I'll read it to you from the report. During the search, Sergeant Vogel observed a pistol grip of handgun underneath defendant Vincent. Sergeant Vogel alerted the other officers defendant Vincent had a weapon. Officer Caldwell looked down and observed defendant Vincent angling her body while handcuffed and holding a gun. Officer Caldwell observed the handgun to be pointed at the face. Fearing for his life, Officer Caldwell drew his department-issued weapon and acquired a target on defendant Vincent. Sergeant Vogel drew her department-issued weapon and acquired a target at defendant Vincent's head. Sergeant Vogel advised defendant Vincent that she would be shot if she did not drop the weapon. She complied. Officers recovered the weapon.
The weapon was up under me, like you said.
So, Your Honor, at this time, we are going to ask for a 10% bond. Lifelong resident of Michigan. She has 4 children. She's had no convictions since 2017 and only 1 prior assault conviction, which was resisting arrest. She is the CEO of a company called Truth is the Way, where she houses survivors of domestic violence. She also has a nursing degree. Now, Your Honor, the most serious of the...
Yeah, it was last Thursday. I'm expecting a job offer. They said I would get a call back Wednesday at the earliest, but it'll be next week. So Wednesday or Thursday, I'm going to have a job.
Offenses of a 5-year felony. I do understand the seriousness of some of the factual allegations, which is why I'm not objecting to a 10% bond, but Your Honor, we're asking that Your Honor not give her a cash bond, especially one that she cannot afford. And so we're going to be asking for a 10% bond.
All right. For the following reasons, I find Ms. Vincent a danger to the community. It's one thing to be in possession of a stolen vehicle. It's quite another thing to be in possession of 1 or 2 handguns. But the nature of these facts are particularly peculiar because it appears that while she was handcuffed, she was concealing a handgun, had it in her hand, and pointed it at the officer, putting their lives, the report says, possibly in danger. Fortunately, she complied per the report with the officer's request, or otherwise she was likely to be shot. And she not only put the officers in danger, she put her life on the line, which is not very, very smart.
I'm sorry.
I'm just saying they're not saying it correctly. They're not saying that correctly. If you just read the report and said it was up under me, sir, there's no possible way.
Miss Vincent, I'm gonna...
Ma'am, everything you say is being recorded and will likely be used against you.
Judge, I'd also like to make a note that this was a stolen handgun as well.
Correct. And so for those reasons, for clear convincing, because of the endangerment of 1, if not 2 officers, the court is going to adopt the recommendation of the people, $100,000 cash, if you're able to, no surety, if you're able to post bond, GPS tether, house arrest, no weapons while this case is pending. We're going to have bond redetermination here on January 3rd, 9 a.m. in front of Chief Judge McConico. Probable cause January 10th. Criminal examination January 17th, both in front of Judge Jefferson. Do you have any questions regarding the court dates and or bond conditions?
What is $100,000 cash surety bond? I don't know. I've never heard of that before.
Okay. You know what $1 is, right?
Yeah, I know $1 is like.
Okay. Well, $100,000 of those, $100,000 bills is $100,000 cash. That's what you need to post bond to get out.
Okay, so does that mean like property as well? Because I own 2 homes and 3 cars of my own.
I said cash, no surety.
Okay.
You don't listen very well, do you?
I mean, I'm just hearing folks me, so it's not a good thing for me. So, I mean, I went to go get a car window fixed and I'm going through all this. It's a lot.
All right. Do you have any questions, any additional questions on your bond and court date?
No, you said everything you had to say.
Okay. Have a good day, ma'am.
Have a blessing, brother.
Who?
Judge.
Break it on.
All right. No, I can reapply to be monetized in 4 days. That's what I was putting up 4 fingers. So my internet dipped a little, so I just jumped off video. I'm gonna keep it off for a couple minutes, and then I'll jump back on. But yeah, she apparently had a gun in the backseat of a cop car while she was handcuffed. That's kind of crazy, right? Now, our boy Reagan, he's gonna come to the defense here. So this is the same case in front of McConico. This is the bond redetermination hearing. And you know Vincent and Reagan go at it. Let's go.
On behalf of Ms. Garner, who's present for bond redetermination.
What's Ms. Garner's bond?
200,000 cash, GPS house arrest.
All right, ma'am, state your name for the record.
Diamond Garner.
Argument.
Judge, Ms. Garner's 35. She does have some prior convictions, Your Honor, from 2007 and 2018, Your Honor. You know, this is a situation, Judge. Ms. Garner has 8 children, and she's lived over at that address for a while, Judge, and it looks like it's a neighbor dispute, you know, but my client is adamant about her not having a gun, not possessing a gun. In fact, I know that there was some other information about a male with a gun, who I think Ms. Garner is stating that that's what this is really about. But because the neighbor dislikes Ms. Garner, she's trying to involve her in this and place her in this. But it's clear in the report there was a male with a gun, a rifle, a gun of some type. You know, and then they also say it was a female. They saw some type of female with a gun, not Ms. Garner, but a female with a gun. Ms. Garner says she never had a gun. In fact, she wasn't even there, and she came later. She came after the fact. You know.
No, unfortunately, there's no way to reverse it. So it looks like someone tried to time out a troll and timed out Jedi instead. Jedi, I'm really sorry. It happens on accident. It's generally just for a couple minutes and you'll be back, but I'm sorry.
Judge, so, and she never shot a gun at a building, period. Never shot or discharged, you know, a gun at a building. She has 8 kids, ages 4 months, all the way to 21 years of age. So she's been, you know, she's had some interesting times, Judge. So she's employed, no pending cases, nothing out here at this particular time, Judge. She's living her life, but she understands that, you know, she can't go back to that location, you know, because it's not a good situation if they're neighbors. You need to go somewhere else while this case is pending. Even when this case gets resolved, you may want to think about relocating so this doesn't happen again. You don't want to just keep coming back for nonsense. So I'm asking the court to consider reducing the bond to a 200,000 personal with the GPS tether, but she would have to be tethered to another location. And that would ensure, Judge, that she is not around the Coyle address. So that would be my request to this court, Judge, and I'm asking the court to consider that.
All right. So while Judge McConico is reading, yeah, Jedi, I'm really sorry that you accidentally got timed out. When comments go by really fast and someone tries to time out a troll, then it's, sometimes it just the comment slips right when you hit the timeout button. You're not the first person and you won't be the last that happens to, but I am sorry. Hey, Jedi's back. Welcome back, Jedi. I actually once made someone a mod when they got accidentally timed out, thinking that would untime them out. It didn't work. So I really don't think there's anything you can do. But it was an accident. But while we're waiting here, if you haven't liked and subscribed already, please do so. But yeah, that's a speaker. That's not, or is that the speaker microphone combo? I think it's just the speaker. I don't see the green light on top of it.
Mr. Prosecutor.
Judge, I consider you probably one of the most intelligent people on the bench, and I know you now to know that the only reason why it took you that long to go through the investigator's report, because you've read through hundreds, thousands of these, is there is so much here. There is so much going against the defendant. And Judge, I speak for, at the very least, this neighborhood, keep a cash bond on this defendant. With all due respect to Mr. Reagan, quite honestly, I don't know what he was talking. We have a confession that this defendant was armed, had a pistol, fired that pistol. We have a confession that was recorded. So, I mean, this is what I wrote down, Judge. And you know how I do my work. I usually get into these, and I did get into this. This is what I wrote. Eyewitnesses, history of problems with defendant in neighborhood, confession of possessing and firing gun in neighborhood, previous threats to kill neighbors. On top of this incident where allegedly there was a shot that was fired. And how ironic, the police didn't find the firearm that she's confessing to, but they find an AR style rifle in her house. So Judge, and then all the other police reports regarding her and her kids threatening, neighbors and individuals. Judge, for the community's sake, I'm asking you to please just keep the bond, or at least keep some type of cash bond.
That's my son's gun.
Hey. Okay. Miss Garner, I would recommend, I cannot give legal advice, but I would just let you know you have a Fifth Amendment right to remain silent. Anything that you say can and will be used against you. So I don't think you want to necessarily start, doing all of that. Because you're fine. You mean, but I'm just saying you might not want to do that. Mr. Reagan, final words. You're muted. You're muted.
Oh, Judge, I've been muted. I didn't know. I'm sorry, Judge. So, I'm gonna be brief, Judge, because I think I know the court a little bit, and I think the court knows me, and the court knows what I think about confessions and hearsay documents, and what I think about, what the police say a defendant says, and how they try to build a case sometimes. And I'm glad Mr. Vincent has done some research or work and look at, the past and thinks he knows what's happening over in the neighborhood, because, there's been threats in the past and all this other stuff. But, the bottom line, Judge, is that, I wasn't there, he wasn't there. People see things differently, hear things differently. And, this case has to go through the process. My client says that there was, she didn't do it. Now, there was a gun, another long gun there. It was, another male there, her son possibly, but at the end of the day, Judge, if you want to separate the two and not have her go back over there, she won't, because you'll put a tether on her and you'll tell her to stay away from there. And that's how we can stop any of this neighborly disagreement, Judge. We're not talking about finding people, halfway across town having an argument. This is some neighbor stuff. It's some ridiculous neighbor stuff that's been going on for years. This didn't happen just that particular day. So let's just separate them, Judge. And I don't think she's a threat to the community, maybe to the neighbor, because they've been beefing. But that's why we put a tether on it and we stay away, and we don't have any problems at that point.
Right. Court haven't heard the arguments of counsel. Court haven't had a chance to read the investigator's report. Yeah, Mr. Vincent is correct in that, I did read this a couple of times, and what did stand out is neighbors, using words like, the defendant and her sons have been terrorizing the community, and just, they're always, pointing guns and bringing guns, and I'm not going to get into whether a son confessed to a murder, but and saying, what happened to them. I mean, that could just be bluster and just trying to puff themselves up by saying they killed the dude across the street. But I live in Detroit, and I really wouldn't want to deal with something like that if one of my neighbors is, we're having disagreements constantly, and there's gunplay and threats and homicides and and ARs and pistols. It's too much. It's too much, and no one needs to live like that. No one needs to live like that. Videos, excited utterances, confessions after being Mirandized, allegedly. It's all too much. And the court does have an obligation to protect the community. Bond is not a punishment, but bond is used to protect the community and make sure the defendant appears at court. So with that being said, the bond is $200,000. There's nothing on the record that would make me think that Ms. Garner would not show up for court. But what is on the record makes me think that Ms. Garner and her boys are, kind of bullied, maybe a little bit aggressive, a little bit, kind of terrorizing the neighborhood. And the neighborhood doesn't deserve that. People in the city of Detroit need to be able to have quiet enjoyment of their homes, their property, the holiday season. Need to deal with this nonsense. So with that being said, court finds that the $200,000 cash bond is an unaffordable bond. Court finds that an unaffordable bond is appropriate in this matter, based on the allegations in this matter and based on Ms. Gardner and her family actually being threats to the community. With that being said, the court finds that $200,000 is a bit excessive, and the bond will be reduced. Bond will be reduced to $50,000 cash with the GPS tether. GPS tether, house arrest, no contact with the complaining witnesses, and she cannot go back to that house where all this occurred. Thank you.
I can get 10%.
You got less. No, you started out at 200,000, and now you have 50,000. So you got 150,000 off of your current bond. You're welcome.
So still can't come home. I got a job. I work at Stand-Up Wireless. I do phone.
And what I would recommend, again, I don't give legal advice, but this isn't legal advice. I would recommend that you or your sons contact your employer and let them know that you're a great employee, you like your job to stay in place, and that hopefully this case will matriculate through the system in a very fast pace, and that that you would like your job to be held.
So
yes.
If the court does consider a 10%, I mean, that if she could post that, I don't know if she could even post that, but that would put some teeth in it to make her have some semblance of having to, comply. Because if she posts $5,000, then
if I did 10%, Mr. Reagan, it would be 10% of 200,000. It would not be 10% of 5,000.
Okay.
No, what we have here is a situation that's pretty. We got to stop this. We got to get it. We got to get a community some peace.
Judge,
we got to get a community some sanity and and let houses be a sanctuary where they can work and come home and enjoy, the fruits of their labor, and not have to deal with the boys and having the guns and the pistols and the ARs and this is what we do, and don't you know what happened across the street? We got to stop that. That's why a cash bond is appropriate in this matter, in this case. In this case.
One last quick thing, Judge. How many times have you heard How many times have you heard how the bullies on the block who are threatening people, shooting people, always flip it on the innocent neighbor and try to make them seem like they are the ones
I
that
have
are the
heard
bullies?
that.
That happens
I have heard that.
That's
And
happening
Mr.
in this
Reagan,
case.
I have heard that.
My
But
client is not the bully, Judge.
well,
Judge, if I could just jump in here and just
no,
really
no,
quick.
Mr. Prosecutor, this is the one time I am going to stop you. I'm not going to let you jump in because I've made the decision, and we're going to go to the next case.
Thank you, Your Honor.
Thank you very much.
Please just give me
Good luck, ma'am.
self-respect so I can come home to my 4-month-old baby.
Ma'am,
They can't take care of themselves. My son is.
Ma'am, I understand, and ma'am, there are sometimes consequences to situations, and we're in a situation right now. You are innocent till proven guilty, and that is where we are. But I've made my decision today, and I wish you good luck.
And we have the next person on the 8th floor, Ms. Gardner, please.
And Judge, just lastly, I think she was trying to say she has a special needs son that really needs care, and nobody else can take care of that child but her. That's what she was thinking.
In all due respect, Mr. Reagan, we have to think about those things. We have to, when we're engaging in conduct, we have to realize we got some things at risk at home, and we need people. People may need us to take care of them, and we may not be able to get out in the streets and do certain things. We can't come into the court case and think about the kids at home, but we don't think about the kids at home when we're in the street and when we're making certain activities. We have to holistically think about the family, think about the job, think about all of that when we're engaging in certain activities. And again, your client is innocent till proven guilty. And I hope as a citizen that everything that you're saying is correct, and that this is all a misunderstanding, and the true culprits will be brought to justice. But as of today, I have a duty to protect the community, and I feel I've done so.
Thank you.
You're welcome.
Ms. Gardner, maybe we have the next person on the 8th floor.
All right. This next one's rough. But excuse me. This next one's really rough. I'm going to warn you now. It's a case of a grown man with a child. So I'm going to warn you now. If you have a weak stomach, don't like this kind of thing, that's fine. I put this in here for two reasons. One, McConico's a badass for this case. And I've got the follow-up from Judge King. And the follow-up is good too. So that's why it's in here. But just to warn you guys.
Justice, but as of today, I have a duty to protect the community, and I feel I've done so.
Thank you.
You're welcome.
I didn't realize it was actually the next case. I have it as two separate clips, and it's literally the next case after one we just played. That's funny.
Ms. Gardner, maybe you have the next person on the 8th floor, please. Okay, on the 6th floor hallway, could you tell me your name, please? On the 6th floor, sir, at Wayne County Jail, what's your name?
Say your name.
Oh, Leo Reyes.
Colin, Leo Reyes. Leo Reyes, case number 230-607-1301. People of the state of Michigan versus Leo Reyes. Defendant is charged with count 1, criminal sexual conduct, first degree during a felony, SORA notice. Count 2, controlled substance, delivery of marijuana to a minor. Count 3, unlawful imprisonment, SORA notice. Defendant is labeled as a habitual offender for this notice, mandatory 25-year sentence. Today is the day time for the bond redetermination hearing.
Morning, Judge Steve Vincent for the people.
Bill Reagan on behalf of Mr. Reyes, Your Honor.
What is Mr. Reyes's bond? 250,000? Was it 25,000? No, it's 250.
No, Your Honor was correct the first time, 250.
Okay.
250 cash.
All right. 1 second, Mr. Reagan. Oh, no. The complaining witness is 13?
Yes, Judge.
Okay, Mr. Ray?
Judge, so Mr. Reyes, Judge, 47 years of age, Judge, lifelong resident of the community. Judge does have some priors. I can say from 2003, 2004, over 20 years ago, Judge, as an FA, looks like an FA and firearms possession, felony firearm, Judge. This situation, Judge, I read it. He's charged, obviously with the serious charges, Your Honor. His bond is 250,000 cash, no surety, GPS tether, home confinement, Judge. As the court, always states, Judge, these are allegations, and we have a process, and you're innocent until proven guilty. Now, the charges are very serious, but I'm asking the court to look at the fact that there's been no prior contacts within the last 20 years. He hasn't had prior contacts with the system. In fact, as serious as these charges are, Judge, I don't know if there have been any allegations previously like this. Obviously it's going to play itself out in the process. So I'm asking for a reduction in bond. Obviously, Judge, personal might be, pushing it, but I'm asking for some type of reduction in Mr. Reyes's case based on his lack of priors within the last 20 years, Your Honor.
Mr. Reagan, what are is there a tether component to the current bond right now?
Judge, there is. There is a 250,000 cash, no surety, GPS tether, I believe it's home confinement as well.
Okay. Court haven't heard the arguments of counsel. See where this gets a little bit added component to this case. Allegedly, we have allegedly we have a 47-year-old man having sex with a 13-year-old. Okay, so now that's pretty heinous there. But we have the possibility that a 47-year-old has given a 13-year-old a sexually transmitted disease that a 13-year-old would have for the rest of her life. Now, I guess it was altruistic allegedly for the defendant to let the child know that he has herpes and to see if she still wanted to hang out with him. And I guess, he wanted to make sure while she was drinking alcohol, dark liquor, I guess, and smoking marijuana and doing drugs with him, that she was okay with doing drugs and drinking with a man with herpes. But I don't know if he thought that she was consenting to the rape and that was okay for her to get herpes. But I'm really confused by that. But again, when we get to dangerousness to the community, the fact that a child would have a long life ahead of her, could have a sexually transmitted disease that she cannot ever recover from at the age of 13. It doesn't get much worse than that. So with that being said, court finds that the $250,000 bond is an unaffordable bond. court finds that in this case, the allegations and the heinous nature of raping a 13-year-old and possibly giving her herpes is a great danger to the community. More of a danger to the community than this complaining witness. I'm sure he would never see the complaining witness again. But that a cash bond, an unaffordable bond, is definitely warranted. Court finds that the $250,000 cash bond is not sufficient in this matter. So the bond will be increased to $500,000 cash with house arrest, a alcohol tether, and a GPS tether, and there'll be the
It's one person, and I know exactly who it is.
only condition for release would be for court appearances. So, Madam Clerk, that's $500,000, an alcohol tether, GPS tether, house arrest, and the only condition is for court appearances to leave the house.
So the court is raising the bond, Your Honor?
The court is doubling the bond. The court finds that the bond was wholly insufficient that was given by the magistrate. And I understand the magistrate was using his or her infinite wisdom at that time, but the court is going to double the bond and add an alcohol tether based on the fact that alcohol was allegedly involved in this activity. So if he posts the $500,000, he's going to have to be monitored to make sure he's not drinking while he's out on bond.
Judge, just so the court knows, the 250 was really an unaffordable bond that Mr. Reyes could not afford. 250,000 cash.
Right, and I understand that. Again, but for the safety of the community, we have to make sure. In this case, there has to be some incapacitation. I'm not going to remand him, which I thought about. I'm not going to remand him. I'm not going to do that.
And Judge, and I understand the purpose of bond is not to punish. I do understand the court has said that, and I just, the court is raising it to $500,000 from 250,000 and all right, thank you, Judge. Thank you.
And Mr. Reagan.
Yes, Your Honor.
If there was just the allegation of the criminal sexual conduct against the 13-year-old, the $250,000 bond would be be appropriate. But the fact that he may have like the herpes portion of it is the aggravated nature. It's the aggravated nature. It's almost like if you torture a victim, or if the fact that he may have given a STD that a 13-year-old can never escape from, that her life is changed allegedly from the rape anyway. But the fact that she has to carry this every day, what this man allegedly did to her, that's the aggravated nature. And that's why incapacitation is necessary through the tendency of this. So whether it's affordable or not, this is a reason for the unaffordable bond. And again, I will say, if a man gives a 13-year-old herpes or puts her and where that is a possibility, incapacitation is necessary. That's necessary.
Thank you.
Get him off the screen, please. Deputy, please remove Mr. Reyes from the screen. Deputy, please remove this man. We have to keep this going. I would like him removed, please.
All right. Now, the follow-up in Judge King's court happened a few days ago. All right, I got to jump off camera. My internet's dropping. Okay, so his attorney, this guy's attorney didn't show up. This guy waited around for about 3 hours. His attorney never showed up. This is how Judge King handled this.
Please tell me why I shouldn't assess you a fine of $150.
Your Honor, I didn't have this on my calendar. It didn't come through the system, Your Honor, through the holidays. I apologize. I didn't know, and I've been on the docket over here at Frank Murphy. I did not. I'm sorry.
I don't understand why it's not on your calendar, it's on my calendar.
Well, I can appreciate. I appreciate that, Your Honor. Mine comes through a different way, so I do understand exactly what the court is saying.
Weren't you present when the date was given?
No, Your Honor. This is a PCC. I was not. These come automatically to us.
it's extremely irritating that not only are you 2.5 hours late, but that we have to call and look for you.
I can appreciate that, Your Honor. I do understand what the court is saying, Your Honor. As I indicated, I didn't know. My office did contact me. I was in court, and the call from the office came just before you saw me log in the first time. And then I had to log right back out. I apologize for having to log right back out.
No mistake about it. I will not be having this discussion again. The next time I have to wait or call around looking for you, I will be assessing the fine.
Your Honor, what I would suggest is if that's the case, the court has the discretion to reassign the case as well.
I can do that too, but I'm still.
Because I'm not in a position to pay a lot of fines, Your Honor, as the court is well aware.
You need to be when you need to be there, like the other people when they're off.
Well, and that's what I'm indicating, Your Honor, and I apologize again, but I don't have total control of that system, Your Honor.
Why is it just you then? Because everybody else appears to show up on time.
I'm not sure, Your Honor, why it's just me. I'm not sure why the court. I'm not sure. I'm not sure. Maybe that's something that me and the court should have a direct conversation about off the record.
Oh, I'm here. We're ready on Reyes. Okay. Your client was sitting here all morning. He's gone now.
Calling case number 230-607-1301. The people of the state of Michigan versus the defendant, Leo Reyes. The defendant is being charged with count 1, criminal sexual conduct first degree, during felony, count 2, controlled substance delivery of marijuana to a minor, count 3, unlawful imprisonment. Defendant is a visual offender for possess notice, mandatory 25 years to 25 year sentence, separate probable cause.
Appearances for the record, please.
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
Excuse me, may I please court, Your Honor, Tyrone Baker, P number 62647, appearing on behalf of Mr. Reyes. Your Honor, I would respectfully request an exam in this matter.
Not guilty and set this matter for preliminary examination. How's January 19th at 10 o'clock?
Your Honor, my only problem is that starting on Tuesday, the 15th, I start a CSC 1 kidnapping case. That defendant has 4 cases that are each set for trial kind of each following week. I don't anticipate all 4 to go. And quite frankly, there was a time where we didn't anticipate any of them. But long story short is that starting on the 15th, I do expect to be in that jury trial, and depending on what happens, could be in jury trial for quite some time. I, of course, can kind of speak with my office as far as what other accommodations that we can make. I'm just not certain, Your Honor, what exactly the layout is going to be over the next couple of weeks. And I apologize for that. It's just that I don't expect all 4 of these cases to go, but I certainly most likely will be in trial on Tuesday through that week, which would cover the 19th.
Earl, what do you want me to do?
If the court would set the matter maybe at least the following week, if not the week of January 29th, it would give me some time that I do anticipate that even if that first case goes.
No, I'm not going to do the 29th. I'm not going that far.
Okay. If the court would set it sometime the week of the 22nd, that would help me at least see what I can do as far as calendar. And I will contact the court to update about what exactly is happening with those cases. And if I need to get someone else to do the exam or something like that, we'll figure it out. I would obviously, given the charges, I would prefer not to have someone stand in for the exam.
Are you waiving the defendant's presence?
Yes, Your Honor. I would respectfully ask the court to waive Mr. Reyes' presence. It's my understanding he was present in court, and I do apologize for the late appearance.
All right, the court will waive the defendant's presence, continue to plead not guilty, and set this matter for preliminary examination on January 22nd at 10 o'clock a.m.
Your Honor, is it possible we could do the 23rd or any other date after that? Just because the 22nd would be the start date of the trial, and I just don't know what's going on.
Okay, what trial? I thought your
Yeah.
trial started the week of.
This defendant has multiple cases that are all set back to back to back to back each week over the next 4 weeks.
Sounds like your office may need to reassign this case. You're tied up for a month.
You're talking about the case before you, Your Honor?
Yes.
I understand. And if that's what happens, that is what we will do.
All right, so I'm gonna leave it on the 22nd at 10 o'clock, because your client is also in custody. I don't want to put it any further out.
Understood. Understood, Your Honor. 22nd.
Judge, if I may, I know that defense counsel has some obviously trials. I do have one set for the 22nd. I don't know if that's for sure going to go. I did just want to make the court aware of that.
But you may have to reassign yours as well, Mr. Like I said, this gentleman, jail.
I mean, to be fair, I'm aware, Your Honor, and I would have been available on the 19th, so I just would let the court know that, so.
Mr. Bigger is not going to be available on the 19th.
I know, I'm aware. Thank you.
All right, 22nd at 10 o'clock. Fine, continue.
Thank you, Your Honor.
All right.
Dawson, file number 2.
All right. That was fun, right? All right. Now we're going into the thruple. If Ed is still here, this is what you were waiting for. This case is debate. The facts of the case are funny. The actual hearing itself is just kind of but the facts are pretty humorous. And yeah, thruple alert.
3-02744, counsel appearance.
Assistant Prosecutor Nate Petrosky on behalf of the people.
Good morning, Your Honor. Christopher Coyle appearing on behalf of Russell Dawson, P49708. Mr. Dawson, could you state your name for the record?
Russell Dawson.
And I should indicate that we would, consent to doing this sentencing by way of Zoom.
Okay, I would hope so, because you decided on your own to appear via Zoom. Everyone else is
Yes.
inside the court.
Yeah,
Okay, so today was the date set for a sentencing. I do have a pre-sentence report. It was prepared on December 20th, 2023. Counsel, did you get a copy of that?
Yes.
Is there-
I've gone over that with Mr. Dawson as well.
Okay, any reasons to make updates, corrections, or deletions?
No, Your Honor.
Okay, you can make allocution.
Thank you. Your Honor, Mr. Dawson is 45 years old. He has no criminal record of any kind in his past. And I should say that he is a very accomplished and successful professional there in the Lansing area. I don't think it's indicated in the pre-sentence report, but I just want to indicate for the court that he works as an LPL financial representative, which supports the Asteria Credit Union and the Lansing Automakers Federal Credit Union. He's a graduate from Florida A&M University. He has a master's in business administration, and he just received his second master's from Michigan State University in wealth management. He's worked in the banking industry for approximately 18 years and lived there in the Lansing area for just over 5 years. He is a very active in the local community. He sits on the board of directors for the Sparrow Foundation and the Lansing Chamber of Commerce, and dedicates a lot of his free time to philanthropical causes. I say all of this to tell you that he is not the typical defendant, if I could put quotes around that we would ordinarily see in the court system such as this. Regarding the pre-sentence report, I spoke with Mr. Sumter at length about it, and both he and I were confused as to after Mr. Dawson was screened for substance abuse, it turned out to be negative for any disorder, which we knew was going to happen. But then the recommendation was for outpatient treatment. So I was going to appear here to suggest to you that Mr. Dawson not have to do that outpatient treatment, but to show you how proactive Mr. Dawson has been, even notwithstanding the fact that it was recommended. He's already done 3 of the 4 weeks that the counselor suggested. So I mentioned that to the court to show you how proactive Mr. Dawson is and how serious he's taking this matter. I want to say this with regard to the facts of the case. I was a prosecutor for almost 30 years in Wayne County. And so I've seen a lot of.
All right. Just got a few more shout outs I want to do. Quinn, Sandy, and Lisa. Thank you so much for the donations. I very much appreciate it. Yeah, I told you this is kind of slow. It's just the facts of the case are what's interesting on this one. But I appreciate everyone who's donated tonight. There's still about 10, 15 minutes left of this, but this is the last clip, so we'll head out soon. And then we'll jump on Discord, where there's a lot going down, apparently.
Things. And I've also been involved in a lot of sentencings and a lot of arraignments. And we often hear the word misunderstanding. It's been used a lot. And sometimes we chuckle about that, but I can think of no other word to describe what has happened in this situation than misunderstanding. And I say that very seriously. And the reason why I can say that to the court and suggest that to the court is because given the fact that he was charged with criminal sexual conduct in the 4th degree, I worked very diligently with the Ingham County Prosecutor's Office to arrive at this disposition, which I believe is a fair disposition with regard to the misunderstanding that happened. I think the Ingham County Prosecutor's Office would agree after talking to the complainant, trying to reach out to the complainant in the OIC. That's why we arrived at this particular agreement here. It's then that Mr. Dawson goes and he's interviewed by Mr. Sumter, where Mr. Sumter makes the recommendation that he be on 6 months non-reporting probation. So I'm definitely asking the court to adopt that recommendation. There's just one more thing I'd ask that the court consider. Is the court's aware under Michigan Compiled Law 771.1, this court, if it determines that this defendant or any defendant is not likely to engage in an offensive or criminal course of conduct, and that the public good does not require that the defendant suffer the penalty imposed by law, this court has not the obligation, but this court has the wherewithal or can choose to take this under advisement. And I would suggest to this court that there's no more appropriate situation than this one here, particularly given Mr. Dawson's past in the sense of his accomplishments and the fact of what's happened here, and the fact that there's 6 months of non-reporting probation being recommended, that Mr. Dawson should be, or I ask the court to take this under advisement pending his successful completion of probation, and there at the end of it, no conviction be entered with regard to Mr. Dawson. The last thing I'd like to indicate to the court is oftentimes, if not all times, there's always the recommendation while a defendant is on probation that he or she cannot leave the state of Michigan. In Mr. Dawson's situation, you know that there's been a number of times, I'm sure the court's aware, where we've asked that he leave the state of Michigan while on bond because of some family obligations he has in Florida. He does have another one that's coming up regarding his new MBA, where he has to travel to Chicago from January 23rd through January 28th. to get his certified financial planner. He's going to Northwestern University for a week of schooling there, and he does have many clients that are in Florida itself. So I'm asking the court that you not impose the restriction that he cannot leave the state of Michigan. He is tied to the Lansing area and will be back. So with all that said, I thank you.
Thank you. Can you recite the court rule or the statute that you were relying on as to why you believe that the court would have the discretion to not enter a conviction against him?
So under MCL 771.1, paragraph 1, it states in all prosecutions for felonies, misdemeanors, or ordinance violations other than murder, treason, criminal sexual conduct in the first or third degree, armed robbery, or major controlled substances, if the defendant has been found guilty upon verdict or plea, and the court determines that the defendant is not likely again to engage in an offensive criminal course of conduct, and that the public good does not require that the defendant suffer the penalty imposed by law, the court may place the defendant on probation under the charges and supervisions of the probation officer, and this would be under advisement. Thereby, upon completion of, or successful completion, I should say, of any probationary term that this court imposes, a conviction would not enter pursuant to this statute.
The prosecution wants to respond to that.
Lolly, hold on, let me turn my camera on for that. Lolly, thank you so much. That was more than generous. I very much appreciate that. Also, Shane, you're welcome. I don't know what you're referring to though, but you're welcome. And then Indigo, thank you so much. That was generous. I appreciate everyone who's donated tonight. It's been an amazing night. Yeah. Well, no, I'll probably pause it one more time before the end of this video, but it's about to get pretty good.
I do, Your Honor. I'll start with this specifically. So while that is in fact the language of the first paragraph of the statute, in the second paragraph of the statute, it states that, this delayed sentencing may happen after defendant has been rehabilitated through the statute specifically lists participation in a drug treatment program. And I just find it a bit inconsistent to first ask that Mr. Dawson not take part in any sort of substance abuse treatment as a term of his probation, and then to suggest that his sentence should be delayed because of his supposed rehabilitation when he's already asking to not go through with the steps necessary for rehabilitation. Additionally, I don't necessarily think that it's unlikely that he would engage in this behavior again. If one, he's not going to address the fact that alcohol played a significant role in this assault, and two, if this is supposedly just a misunderstanding, that does not sound like the argument that would be made by someone who understands the seriousness of their actions and thus would be likely to reoffend.
Mr. Quirrell, do you want to respond? Then I also want to give Mr. Dawson an opportunity to address the court if he would like.
Yes. Your Honor, for the very reason why Mr. Dawson took it upon himself to engage, all I'm saying is I just think the prosecutor's misunderstanding or misinterpreting what I'm saying. All right. This is not, I think we can all agree as the three lawyers here that this is not a situation where, given the fact that he tested negative for any substance disorder, then they went ahead and recommended outpatient treatment. We don't generally see that, right? I think we can all agree on that. The outpatient treatment did not fit the reason or why he tested negative. In any event, yes, I would have asked that he not participate in that. However, he did go and participate in it on his own volition, and he still will go complete the fourth and final week of that outpatient treatment. therein he fits within paragraph 2 of MCL 771.1. He is showing to the court that he's rehabilitated. His background does show to the court that he's not likely to engage in any criminal offensive conduct. It's not Mr. Dawson who's saying that this was a misunderstanding. It's me that's saying that it was a misunderstanding.
Mr. Dawson, do you want to make a statement on your own?
Your Honor.
Thank you,
all I
Lucy.
can
I
say
appreciate
that
it.
I never could have imagined by any circumstances that I would be in this situation or sitting here with this happening today. I am happy that I've had the opportunity and happy to finish the fourth visit to substance abuse because I want to learn. And if there was even a chance that there was a disorder, I would not ever discount it. I'm not better than anyone else. I just want to make sure that I'm a good person. I have lots of clients and family that trust me, not just to be a good man, but to be responsible with their business. So I would have never imagined I'm here. I was here, would be here. And really that's all I'd say. I never imagined I do not take this lightly. And I certainly wouldn't use the word misunderstanding, as Mr. Coyle said. That wasn't my word. But if there was any unintended, if something was seen the wrong way, I want the court and the victim to know that I apologize for that. I would have never imagined having a couple of friends over with me to
Okay. And just for the record, you're not objecting to his delayed sentencing. You're just objecting to if he's given delayed sentencing, what should be required. Was that correct?
I would be objecting to both. The delayed sentencing was not a part of the plea agreement as it was. This was a criminal sexual conduct case that was pled down to an A and B. So Mr. Dawson is already, I would say, benefiting from that plea deal. And I think that issuing a delayed sentence in this case would be, it's not required by the plea, and two, I think it would be inappropriate given the nature of the case. But if he were to receive delayed sentencing, then I would also be objecting to the requirements that he not take part in some sort of substance abuse treatment.
Okay, well, if you're taking the position that due to the nature of the case, it was so egregious that he should have a delayed sentencing, why would it have been pled down to an assault and battery? That's rhetorical, not for you necessarily to answer, just to consider. Because if it was that egregious, it would not or should not have been pled down unless there's some other factors that you had to take into consideration. This was a no contest plea. I read the police report into the record. I reviewed the police report, the affidavit of probable cause even before reading the police report. And I tend to agree with plaintiff defense counsel, which is that this is a circumstance that I do believe alcohol played a underlying role. Not that I believe that, based on what I have here, that Mr. Dawson has an issue with alcoholism, but I believe that alcohol played a role, that it was some potentially poor choices made. Based on what I read, not only poor choices made by Mr. Dawson in that incident. I read these facts, at least the facts that was put on the record, and I could see how this was a misunderstanding. Even based on what was stated in the police report by the alleged victim as to what the third person said, that third person was in shock at what happened based on what the police report states. And that's all I had to rely on for the facts. So there's nothing before the court, not the offer, not the pre-sentence report, not even the report that the court had to use to establish a factual basis that leads me to believe that this would
be a circumstance that Mr. Dawson had not learned from and that he wouldn't put himself back in this position. I would hope not. I would hope that based on what I see here in this report, which is the things that he has worked hard to attain and the things that he's continuously worked hard to attain, and not having any prior criminal history other than some traffic offenses, that he would have a reoccurrence of this type of behavior, or that he has an issue with alcoholism. I don't see that. And I also think that he has taken some effort, I don't know exactly what that's been, for him to address some of the classes or the issues that were addressed.
Did they not say it yet? I know they kind of bounce around it, and I feel like the judge says it. If they didn't say it yet, I don't want to ruin it. But I feel like the judge does say it.
By Mr. Sumter in the report, and Mr. Sumter again is recommending non-reporting probation. Non-reporting probation, I wouldn't even require him to test regularly. That was the recommendation of probation. So even probation doesn't believe, and it was confusing to me when I read the recommendation. You're asking for non-reporting probation, but then you want me to have him participate in some outpatient substance abuse to deal with some coping skills. And coping skills, I don't know if this was something that he used alcohol for the reason to cope, or he just made a poor decision in a situation where he's in the house drinking with two females in his bed. I don't see how under any circumstance that doesn't create a opportunity or avenue for misunderstanding. You have two females in your bedroom, in your bed with you when you're drinking. That is a recipe for a misunderstanding. Unless you're getting consent up front before they enter your bedroom as to what you think is about to happen, you should more likely than not foresee yourself in this situation. I hope Mr. Dawson has learned his lesson. It's an unfortunate situation. This is an incident where he put his entire livelihood on line for a stupid mistake or error. I don't know if what the victim's perception was what Mr. Dawson's action was. Again, there was a no contest plea, but either way, it was a very poor decision. I think that the recommendation for non-reporting probation is appropriate. I am going to grant the request for a delayed sentence under 771.1. Can you remind me again what he's already participated in as it relates to the substance abuse treatment?
Yes, Your Honor. It was recommended that he do 4 weeks of the outpatient treatment. That's the 12-step program. And he's completed 3 of those weeks, and I think his 4th and final might be next week. Is that correct, Mr. Dawson?
Yes.
Yeah. So he'll have completed it next week.
Okay, I'm going to make that a requirement.
All right. There's only a minute or two left, so I'm going to peace out. I'm going to say my goodbyes. No, it's not illegal. One of the 2 women claimed sexual assault. So that's what he's charged with. He was charged with sexual assault. And that's why his attorney fought so hard, was saying it was unusual. And yeah, so it took a long time to get to it. But he had 2 women in his bed. They were all drinking, and one of the women claimed sexual assault. So that's where the judge was just like, But I want to thank everybody who donated tonight. Thank you so much. I appreciate it. It means a lot. Kind of a loss for words. I will go live tomorrow. I'll put a good thank you together for everybody, like last time. I very much appreciate it. And it's the last time it's ever going to happen. Things are looking up. 2024 is going to be a good year. But yeah, if you guys haven't liked and subscribed already, please do so. If you haven't done your jump kicks, backflips already, Cardio is important. I will be in Discord after this. I have one thing to take care of before I jump in Discord, so it might be a few minutes before I'm in there. There's always a bunch of people hanging out after the streams, and it's a lot of fun. So if you want to join, join. But until next time, bye.
It looks like he's been proactive even as it relates to doing that. I don't believe, based on his assessment or his report and investigation, that there is an underlying substance abuse issue. I think the issue is probably stems from making poor decisions when you have people that you don't know that well in your home and in your bed, in your personal space. But as you are hopefully moving forward with your life, you've learned from this, and you won't find yourself in this situation or any additional situations that places your livelihood or your liberty at risk. The court will adopt the recommendation. The recommendation is for 6 months non-reporting probation. You will complete the third or the fourth week of the treatment course that you've been already participating in, and you'll provide evidence of that to probation upon completion. I will not impose a travel restriction while on the probation. However, I will continue the no contact order with Ivana Ruiz.